Thanks for joining today. So, in previous episodes, we talked a little bit about the Department of Education and how it was, whether it's constitutional for the Department of Education to be eliminated. And we've talked a little bit about theories of interpretation that the Supreme Court and other scholars might take on constitutional theory. And so today, what we will be talking further about is a little bit of a mix of both of those, it sounds like. And so talking a little bit about what's happening with the federal agencies and also taking a closer look at something that you had mentioned previously, Ken, called the Unitary Executive Theory and how that might be playing a role in what's happening today. And so with that, hi, Ken, how are you?
I'm good, Sadhna. How are you?
I am doing all right. And so I'm really excited to have this conversation with you today to better understand what's happening, not just the Department of Education now at this point. There are a number of cuts that have been made. Could you tell us about what Donald Trump is doing to the federal agencies and what might be underpinning some of that?
I'd love to, Sadhna. Obviously, this is a very difficult train to keep track of. We are seeing just headlines every day that I can really only roughly categorize what's going on since the specifics of it are changing just dramatically day by day. I have a hard time keeping up. And that's even just the very basic broad strokes of what's going on. So obviously, as we all know, the Department of Government Efficiency, which is headed up by Elon Musk, had started with firing probationary workers across the government. The probationary workers that were fired were not under Elon Musk's agency. They were in all sorts of different agencies, and they were not under any agency that it is clear he had any authority to fire them.
And
They were
actually, can I
informed they were
pause you
let
there
go.
to ask you a question?
Sure,
Because I've heard this
sure.
before. Is the Department of Government Efficiency an agency?
Agency is an interesting term. It is certainly not a cabinet agency. It is not an agency created by Congress. If you take a very broad look at the word agency or the term agency, there are agencies that are created by presidents, and they are usually sub agencies. And in this particular case, it is essentially an agency of the White House, which he can do. He
Okay.
can create a group of people, call it an agency. There's no particular problem with calling it an agency, but it doesn't, in and of itself, give it powers, just the fact that he calls them agencies. What a power an agency has is something that is determined by looking at the specifics of what authority were given to it, by who, under what circumstances, for what purposes. So you can call DOGE an agency, but it is not an agency that has actual strict legal authority over all of the many agencies where employees have been fired, especially probationary employees. So the firings by Elon Musk, or in theory by Elon Musk, although the agencies have been the one that have carried it out, that is just one category of firings that have been done. This has been followed by what would be referred to as RIFs, or reductions in force. Reductions in force are normally done after a very slow process of evaluation and of essentially procedures which not only evaluate when jobs are going to be basically taken away. So this is not firing individuals and then leaving the jobs. This is actually eliminating the job positions. Taking away these jobs is normally done over a period of several months after a lot of evaluation. After that is done, then there's a very elaborate procedure for reassigning the workers who are in those jobs based on things like seniorities and preferences, et cetera. And these kinds of decisions are generally appealable to various boards that are then given the authority to evaluate whether or not these are consistent with the existing law that allows for the agencies to do these kind of RIFs. So as far as we can tell, these RIFs are not being done consistent with those laws, and people are just being let go under things that are called RIFs. But in some ways, we don't even know specifically whether that is the authority that is being used. All we know is that they are saying that they're eliminating positions and then letting people go. So those are two of the major ways that people are losing their jobs. And then the third thing, as we talked about previously, was the statements are being made that we're closing the Department of Education, we're closing agencies such as, they're talking about Institute of Peace, closing USAID, but the ability to close an agency is just not something that is within the authority of the president. If the president created an agency, he could probably close it. But if Congress created an agency, then the president doesn't have the authority to close it. So these are very broad powers that are being claimed by the president as something within his powers. And of course, what that means is as soon as these things are done, they're immediately litigated. And it's been so extreme that we have now probationary workers who have been fired, then rehired, and now it appears that they're being fired again. So that's the kind of confusion that's surrounding all of these different actions by the Trump administration.
Thanks, Ken. And so it sounds like it's unclear what authorities they're using to do the firings in the first place, and then they're getting reinstituted. And then do we know how they're refiring them? Is that clear? Are they using any sort of statute or any other authority to
That
do the
that's
refiring
essentially
after they've
now that's essentially just this different stage of litigation. That was in that case, the Supreme Court essentially basically held that for the purposes of probationary employees, that the judge below did not have the authority at that particular time to have
I see.
reinstated the probationary workers. So it wasn't a final decision on the merits, but it was just a procedural decision that the probationary workers could be fired again. And then maybe they'll be rehired again at some point in the future.
Okay. And I appreciate that you said this has happened in previous administrations, but done in different ways. I think I remember in the Clinton years, there were some sort of reductions in force that took place. And I don't know if it was an actual RIF or if there was another way that kind of folks were, there was a little bit of trimming of agency personnel.
Most administrations have gone through some level of rifts. For instance, I worked for Congressional Research Service, and we had for many years a clipping service. Most people probably don't even remember what a clipping service was, but a clipping service was a large number of people in a room literally clipping newspapers and providing clips of those newspapers to congressional offices who are interested in particular topic areas. So, for instance, if an Idaho senator was interested in farming issues in Idaho and a newspaper wrote an article about that, then somebody would clip that article out of the newspaper, put it in an envelope, send it over to them. So that was a service that was very important in the pre-internet age. And as the internet grew and became more efficient, eventually those people really were not, it wasn't necessary to have those jobs anymore. And so there were rifts in my office where a number of people were let go, not by firing, but essentially by having their job positions eliminated and then having a orderly shutdown of that division because there really was no job left there for the people to engage in.
Yeah, that's really quaint. And so I love that this type of thing has happened in previous administrations. I don't think it's happened at this scale. And so what makes it shocking in this moment then? Is it the scale?
Let's just say that there's two or three things that are shocking. I'll start with the fact that we're talking about the violation of several different laws at the same time in large quantities and with really very little regard for court review, waiting for court review, doing internal procedures to wait for compliance, to wait for evaluation of whether there is what's being done here is appropriate. For instance, the probationary employees that were fired, there is pretty quick decision making by some federal courts that those were arbitrary and capricious decisions because people were not fired because of their failure to meet certain standards of performance, because probationary workers really don't have a lot of protections, but it is still the case you can't just fire a lot of people at once who have completely different circumstances if you have no basis for doing so. And so that appears to be a violation of the Administrative Procedures Act. Firing a bunch of people who have protections under the Civil Service Reform Act, that seems to be violating another law. And then riffing people without really giving them the ability to challenge why their jobs are being eliminated and whether they can then go into another job. That appears to be a violation of Federal Veterans Preference Act and subsequent legislation. So not only are those laws all being challenged at the same time, but there's actually something much deeper going on here. And this is where I'd like to address the issue of the unitary executive theory. So, in later podcasts, we can address the unitary executive theory as it first was presented to us. In the 1980s, the unitary executive theory arose in a much more obscure context. Back then, it was a theory that had to do with something called independent agencies. Now, I don't want to go into too much details, but the difference between a cabinet agency or more cabinet-like agencies and independent agencies is that cabinet agencies are agencies headed by usually a secretary or some individual agency official who can be fired by the president at will for no reason, essentially. The president just disagrees with them, has no particular problem with them, but just wants somebody else in there. All the perfectly valid reasons to fire that person. Independent agencies have a much different history. They are regulatory agencies. They do things that look much more like courts, or because they adjudicate, or they look more like Congress because they pass regulations. These independent agencies are generally headed not by agency heads, but by commissions. They tend to be very expert based, and they tend to be professional based and nonpartisan, and they tend to be bipartisan. And the idea being is that these are regulating generally businesses and individuals, and they are not supposed to be so much exercising the kind of executive power that you traditionally associate with cabinets agencies, but they're really supposed to be doing more kind of regulatory work. The unitary executive theory arose from the idea that independent agencies shouldn't have a limitation on the ability to fire agency officials. So right now, an independent agency is characterized by the fact that in order to fire an independent agency commissioner or agency official, you have to have some kind of cause. You have to show that they are either engaged in some malfeasance or some inefficiency, or they've done something wrong. It's not just an at-will hiring and firing. There has to be some kind of basis for it. So the unitary executive theory was this kind of academic theory that has gained some toehold in the Supreme Court, that maybe independent agencies was a step too far, even though it's been around for a long time, and that maybe independent agency officials should be able to be fired by the president. So that was in the 1980s. Fast forward to where we are now in the 2025s, and the unitary executive theory has now taken on this much, much broader, much more incoherent, really almost political rhetoric theory, and that is that the president can do anything he wants with the executive branch, meaning he can hire or fire anybody. He can decide whether to open or close agencies. He can decide whether or not to spend money, which is called impoundment when you don't spend money. These are very broad powers that there is Supreme Court case law saying specifically that these are powers that the president doesn't have, at least as if the Congress doesn't give them to the president. And now the unitary executive theory is being used to argue that, in fact, the Congress doesn't have the authority to pass these laws at all. When I talk about these laws, I'm talking about laws going back hundreds of years, at least 100 years, 150 years, if not more. And these are laws that have to do with Congress's part of the separation of power structure of our Constitution. And what the unitary executive theory is now being used to argue is once Congress has created an agency, passed a law, decided to spend money, that they now have no more power. Now it's up to the president to decide whether he's going to enforce that law, spend that money, allow that agency to continue, whether he's going to keep employees around, whether he's going to fire them all, put in all his own people. This is a extreme variation on what was a very, very narrow academic theory. And it is really representative of nothing in case law. And what it's really not representative of anything in originalism. So we spoke in a previous podcast about originalism being the idea that if you don't see it in the text of the Constitution, that's a strike against it. If you don't see it in the history of the early country, it's a strike against it. The idea that new things, new powers, new expressions of constitutional power is not something you find in the Constitution. That's really that's the opposite of what originalism and these more conservative constitutional theories are. That's really one of the more alarming things about the unitary executive theory, is that it is now becoming very apparent that there are arguments being made that the executive now has powers that nothing we can see in the founding fathers documents, and certainly nothing we see in the early actions of the Congress. There really is a things going on in the legal and the kind of the legal academic constitutional area that are surprising even for things that are politically concerning in and of themselves.
Yeah, I have kind of two questions I think that are coming up for me. One is you've identified this as a legal theory and that the administration is using this legal theory that's an academic theory. Like, it doesn't have the force of law. So, how does that play out that they're using this theory in their arguments? They're not using legal precedents, they're not using something else. How do they use a theory in their arguments?
That's a great question. So the answer is that you will not generally see this legal theory being cited particularly often in actual litigation. And there's a reason for that. It's the same reasons that we are not seeing a lot of separation of powers being made by people who are challenging these kinds of moves by the administration. And that's that there is a theory of judicial jurisprudence, which is mostly being adhered to, not always. And it's true at both the lower court level and the Supreme Court level, which is you decide the case in front of you and you decide it at the least, shall we say, the least significant level of a court decision. So if you can decide a case on standing as opposed to reaching the merits, you decide it on standing. If you can decide it based on procedure rather on the merits, you decide it on procedure. If you can decide it based on statutory grounds rather than on constitutional grounds, you decide on statutory grounds. The idea is that you decided on the narrowest legal grounds that you can. So what's going on with a lot of these cases is that there are so many different ways that these cases are coming up. They're coming up in ways that are probably procedurally questionable. They're coming up in ways that are questionable in terms of the violations of the underlying laws. They're coming up in ways that a lot of different people are trying to get standing. They may have a hard time getting standing. So it is the case that it actually could take a long time before you ever got to this deeper argument, which is whether or not the president actually has the authority to do these things, or on the other side, whether the Congress has the authority to keep the president from doing these kinds of things. And I will say that to some extent, the longer it takes for federal employees to challenge a being fired or to challenge a large scale RIF, these are the kind of cases that sometimes will become moot because the federal employees can't afford to keep litigating. Now, most often it will be their unions that keep litigating, but in many cases, the federal employees will actually have to move on if they haven't been able to get a court to keep them in their own case, in their own position. And so in some cases, even if you get to the point where there has been a positive court ruling, then there may be not that many federal employees left in place who would be affected by that ruling and who would be able to get a successful effect by that ruling. And if that ruling never reaches the unitary executive theory in any real depth, then it's almost a win for the theory, which is that it never actually gets tested in court. It's used as kind of a political precedential theory underlying the actions that we're taking, but it never actually gets in front of, most importantly, the Supreme Court to be tested as to whether this is actually a theory that's going to hold some legs. Now, having said that, the unitary executive theory, again, at some marginal level, mostly involving the independent agencies, has gotten some foothold in the Supreme Court. And so at that narrower level, there is certainly some idea that the Supreme Court is sympathetic to the idea that there is power in the executive branch that perhaps Congress shouldn't be able to step into. But having said that, I believe we can quite reasonably argue that the Trump administration has gone far beyond what the Supreme Court is willing to put up with.
Yeah, and that's really helpful, and the second question that was coming up for me is in the Loper Bright Enterprises case, in last year's Supreme Court term where they overturned Chevron deference, and I know we're not going to go into administrative law at all, but the kind of theory there was that Chevron deference, where we were for decades giving deference to the executive branch and how they interpreted congressional appropriations, the legislative language, the executive agency was then able to interpret it, and there was deference given to that interpretation of the executive branch. And then last year we saw that the Supreme Court said, no, actually, we're going to let judges do that, like the judiciary, to have that deference, and felt like it was weakening the executive branch in that way. So I think it's really interesting that I wonder, did that happen in anticipation of a different executive leader than we see now? And now that Trump's in office, he wants the power and the executive branch wants this power. And so they're exerting it in a different way. In some ways, if Chevron deference was still standing, they might have even more kind of legal standing to do some of the moves that they're doing right now. Maybe that's not a question, it's just a statement.
I think what you're really referring to is what I would feel is more perhaps tides and waves within the judicial theory and judicial interpretation and judicial waves. I do think that for many years it was the case that interpreting statutes in a way that gave significant deference to agency discretion was associated with liberal agenda items. And there was a fairly good reason for that because during the 60s and 70s, there was a lot of liberal statutes passed, and a lot of it did have some fairly broad language in it. But a lot of statutory language was pretty much the basis for what could be done, what had been done. And once that kind of language, that kind of statutory stuff was no longer being passed in the 80s and 90s, it really became the case that to move things forward, whether it be environmental, or whether it be regulatory, or whether it be forgiving student loans, things along those lines. And the only way to really move forward the more liberal agenda was done through the executive branch, was done by regulation, was done by executive order. And I certainly do think that for a long time, the idea of deference to the executive branch agencies was seen as something that allowed more, and I shouldn't even necessarily say liberal, but just more deferential to the idea of more regulation, the fact that agencies should be able to take broad language that Congress had put forward and to use it to perhaps extrapolate into other areas that wasn't necessarily at issue when the statutes were passed. And so I think the loss of Chevron deference certainly was associated with that kind of idea that we should be more restrictive of what agencies can do. And that certainly was a long standing movement against agency deference. And so I think it was that was the end of the tidal wave moving forward. And really what is more interesting is why the legal theory of unitary executive would start rising up in some ways in kind of opposition to this. And certainly this has come out of, I think we talked briefly about the Federalist Society, which is an organization associated with more conservative students, law professors, justices, lawyers, that has been pushing for a stronger executive branch. And it's interesting as to what the politics of that are, why a stronger executive branch would necessarily be seen as fitting more comfortably with a conservative agenda, but that certainly has been the case. And so I think that unitary executive theory is something that has certainly been put forward by the Federalist Society, and it's something that they're more comfortable with. The fact that it does seem a little to be at odds with the Chevron deference line of cases, I think is almost more of a historical accident or a couple of ships passing in the night and not necessarily noticing each other as they went off in what really are almost two separate directions.
I see. And then, so you talked a little bit about whether the president can shut down an agency created by Congress. The answer is no. Has there been case law on this point?
There is nothing significant that I can think of. What I find most interesting about this argument is that the Department of Education, using that again as an example, was, I believe, created in 1979. By 1980, President Ronald Reagan vowed to close the Department of Education. Of course, he intended that it be closed by legislation. Since then, most Republican, I believe, platforms have wanted to close down Department of Education. Many pieces of legislation have been proposed for Congress to close down the Department of Education. There have been 4 presidential administrations, Republican presidential administrations since that time. Nobody tried to close down Department of Education by executive order. It would suggest that no Republican president or anybody on Capitol Hill believed that Department of Education could be closed by the executive branch without any input from Congress. So I think that's one kind of interesting note. And I also just think that if you just read the executive order itself, when you get, first of all, it's very short. And if you get to the end, 3 or 4 lines that say things like, this executive order shall be implemented consistent with existing law. What does that mean? To me, it means you can't shut down the Department of Education. And then it says 2 or 3 other kind of similar things. And so bottom line is that I don't think the executive order was really ever intended to have any particular ultimate impact, except for to serve as a press release and then to move on, because again, Congress created the agency. There's certainly nothing in the Constitution that says presidents can close agency. And if you're a textualist, an originalist, I don't know what other kind of ist, but I can't really articulate a constitutional theory of interpretation that would allow for the president to essentially let Congress open an agency and the president close it the next day. I just can't imagine what kind of separation of power theory that would be.
Thanks, Ken. And you talked a little bit also about whether the president can refuse to send appropriate money. So if the president can't shut down an agency created by Congress, and then the next kind of step is, can the president refuse to spend any appropriated money, not just the agency? And I'm curious how the unitary executive theory has been used in this capacity.
But again, I think it's just the same rather vague argument that's used. You're not going to see it in any particular court filing. I'm sure you'll see it in some maybe statements that have been made, but it's pretty clear that there is a law against impounding spending. It's called the Impoundment Control Act. There's Supreme Court case law on it. There is a decision, the Clinton versus New York was about the line item veto act, but that was essentially saying that if Congress passes legislation providing money, then you can't then give the authority to a president to decide, no, won't appropriate that money. We won't spend that appropriated money. So we have Supreme Court case law on it. It seems pretty straightforward. Wasn't even a particularly contentious Supreme Court decision. And it is just one of those things that just seems rather obvious. The idea that if Congress can just pass an entire budget and pass an appropriation and get it through all the committees and the president signs it, and then the next day he just sends it all to the Treasury, and then they cut a big check and just, I don't know what they would do with it, invest it in T-bills or something like that. It just doesn't make any sense. It doesn't really fit into anybody's perception of how government would run. It belies the fact that Article 1 not only has literally dozens of powers in it, but it has the necessary and proper clause that says Congress shall pass legislation to basically effectuate into the execution of all of the powers that came before, to effectuate the execution of all these powers. And then most of the unitary executive theory is just based on 4 or 5 words at the beginning of Article 2 that says the executive power shall be vested in the president. And that's it. That is, they managed to talk about hiding an elephant in a mouse hole. That is the counter to this huge number of powers in Article 1. You just take those 5 words, and then suddenly the president gets what's essentially a veto power, even though, remember, he has a veto power over the legislation. Essentially just saying he gets a veto power over anything Congress does as long as he's doing towards agencies. And remember, if you look at the agencies, which is that the president yes, he gets the vested executive power, but he gets to appoint agency heads. If he runs the agency, why did he need to appoint agency heads? Or you look to see the fact that he's commander in chief. That makes sense. He gets to run the military. If he gets to run the military directly, which he does because he's commander in chief, why did you need to give him that? Because if he gets to run all the agencies just the same way as commander in chief, why did he need the commander in chief authority? It's just the Constitution is
Yeah.
just filled with examples of you need the agencies to be separate from the president. And from the beginning, if you look at the legislation for agency power, it is power given to the Secretary of Commerce, power given to the Secretary of the Navy, power given to the Secretary of Treasury. It's not power given to the president. So we're just talking about going back to the very, very beginning of our country, looking at what Congress did, looking at what the founding fathers did as they sat in Congress and saying, none of that matters because I've got 5 words in Article 2, and that pretty much just preempts anything that they said before. Again, it's nothing. I can't imagine making this argument in front of judges, but you certainly can make it in the newspaper and you can make it as a matter of political rhetoric. But I just can't quite imagine making it for some of these arguments that they seem to be making it for.
Yeah, and I think one of the things that's really striking to me about like, the attempted application of the unitary executive theory is that y the kind of people within the separation of powers that have the most to lose is Congress. So you would think, like, our elected officials would be enraged by this, right? Because it's their power that's being stripped, and obviously, us as the people that they're representing, we should be enraged as well. But I don't hear a lot about that. So maybe it's the case that you're saying of making the argument in court versus the headline, but I think this is the headline too, is that this power is being stripped from them, and they should be enraged.
It's a very interesting political dynamic. I'm not sure that I could think of any precedent. It has certainly been the case that our various institutions have, to some extent, been protective of their own authorities. It's certainly the case that Congress has given the executive more authority over the years, but they've generally done it by legislation. The idea of doing it by just not objecting to actions that seem to be in violation of the separation of powers seems fairly unprecedented. We might have to go back pretty far to find other good examples of it.
All right. Thanks, Ken. I think today we talked about what's happening with the federal agencies and a distortion of a unitary executive theory that's being applied right now and in kind of ways that may not have been anticipated even in the initial articulation of the theory, like how that plays out with how that could play out with agencies being shut down and the refusal to spend appropriated money and the termination of federal employees. And I don't know if there's anything else that you wanted to mention today. I know we covered a lot of ground.
All I can say is this stuff is so new that I actually have to go back and look to see what is being articulated by who. Again, the idea that the unitary executive theory, which has been around for a while, is being used in this new and really very unusual way is, I just think, unprecedented, and it's not something enough that people are paying attention to. And I think it's something that people really should be aware of and that people should be objecting to in a much more serious way than anybody is.
Thanks so much, Ken, and thanks for drawing my attention to it and everyone listening. I'll see you next time.
Thank you, Sonia.
Thank you.